Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. It is Friday, May 19th, which means we are exactly 12 days out from the absolute final deadline to bring your firearms with attached stabilizing braces into compliance with ATF's new rule as it relates to firearms with attached stabilizing braces. Now, we have done videos before where we were going to wait, and then we did a video, that's one right here, where we actually did drop 2 firearms into the hopper. We did that the first part of May. Many of you are still waiting, and I understand why, and many of you are waiting for something to break free, something to happen that hits the skids on this thing and allows us all to live free like Americans once again. Well, maybe, just maybe, that opportunity is beginning to present itself, because there is a bit of a Hail Mary pass that's being thrown by one of the plaintiffs in one of the cases challenging this. But when you take a look at what they're doing and who they're doing this to, that is going to the Fifth Circuit, maybe this actually has a chance, could get legs, and might save us. So today, let's spend a few very important minutes and talk about the last-ditch effort to stop ATF's pistol brace rule. Okay, so the case we're talking about again today, and we have talked about this case, is the case of Mock v. Garland. Now, Mock v. Garland is a case that was filed in one of the district courts in Texas. It is a challenge to the implementation of ATF's new rule 2021 R-08F, better known as the pistol brace rule. Now, one of the arguments that was made at the trial court level immediately was an argument for an injunction, a nationwide injunction. That was ruled on clear back on March 30th, and the court went, nah. And the interesting thing about that is, even though it was a George W. Bush appointee who had presided over the case, that judge denied the preliminary injunction because they believed that the plaintiffs had failed to show that they were likely to prevail on the merits, okay? Now, what that did, of course, is the plaintiffs immediately appealed to the appellate court in that case. And even though that issue was completely briefed, completely argued, and they've been waiting to get a ruling, thumbs up or thumbs down on the injunction, they have yet to receive a ruling. So what the plaintiffs did here, and this is the Firearms Policy Coalition that's spearheading all of this, so obviously this litigation is in really good hands. What the Firearms Policy Coalition has done is they've now applied for injunctive relief from the Fifth Circuit Court of Appeal. So they have now made an appeal, filed a petition with the United States Court of Appeals for the Fifth Circuit, okay? And they are basically asking the Fifth Circuit to intervene and to place an injunction on this. And they want the hearing, and this is important. This is really good strategy by FPC here. They want to have this resolved in a hearing no later than May 24th. Why? That would give all of us exactly 1 week. If the injunction does not go into effect, it gives all of us exactly 1 week, if we so desire, to bring our firearms into compliance. Now, I know many of you out there are going to put right in the comment section right away, I ain't doing anything, I'm not going to comply. I get that. That is your life. You have the right to do that. Our job here at Washington Gun Law is to tell you where the law sits, tell you where the lines are. You get to decide whether you want to scribble inside or outside of them, okay? Now, in challenging the district court, the trial court's level finding, the plaintiffs in this case are arguing to the court as follows. The court should enter an injunction pending appeal because the district court's analysis of appellants' Second Amendment rights flipped the burden of proof by faulting appellants for not providing evidence of negative, the lack of historical analog to the final rule, even though both the Supreme Court and the court's precedent places the burden of historical justification for any restrictions squarely on the government. And when you do go back and you read the original opinion, they were basically saying, well, listen, you're the plaintiffs here. So if you want to challenge this law, can you demonstrate to us that there is a lack of history, there is no historical support for this? That is not how it works under the case law. It is very clear that when the plain text of the Second Amendment covers that type of conduct, it is presumptively unconstitutional unless the government can demonstrate through historical analogs that we as a society have accepted those types of firearms restrictions. The burden of proof is on the government to come forth. The plaintiffs in this case who are challenging the law, but they are not the government, they do not have the burden of proof in establishing that historical precedent. Now, I know what some of you are asking yourself right away. Why is this thing going to be any different? We saw all these other lawsuits puffing their chest out. We saw all these congressmen puffing their chest out. We're going to stop this rule. We're going to stop this rule. And here I am doing a video on May 19th, and the clock is still ticking. Why do I think this could gain legs? Well, let's take a look at how the Fifth Circuit has ruled on other Second Amendment issues just this year. Let's start first with United States v. Rahimi. That is a case that ruled that court orders which require individuals to forfeit their Second Amendment rights pending allegations of criminal conduct or civil protection orders was unconstitutional, thus striking down federal law that had been in existence since the 1960s. Okay, that's the Fifth Circuit. What else did the Fifth Circuit do? Well, you may recall the case of Cargill v. Garland. What is Cargill v. Garland? We talked about this case already, and that is a case that struck down ATF's banning of bump stocks. They found that to be unconstitutional, and in both instances, the court very strictly applied historical analysis to the new legislation and determined that there was no historical analog that supported any types of these restrictions and struck down both. So this is a court that has demonstrated a propensity and a willingness to throw their hat into this ring, to get into a bare-fisted fight over this, and to actually stand up for individual liberties. So yes, if the court is willing to accept review and consider this, and yes, apparently the plaintiffs already notified all the appellants on this case and let them know that this was coming so that they could be prepared. There is a possibility that the court could hear this issue as early as May 24th. And is there a possibility, if they hear this, that they can issue a nationwide injunction sometime before May 31st? It is possible. Plaintiffs were very wise in pointing out that the remedy that is necessary to avoid the irreparable harm here is in fact a nationwide injunction. And I thought they did a really good job of connecting the dots as why. This is how the pleadings stated. In order for relief to be effective in this case, the injunction pending appeal must pause the final rule in its entirety, not merely as to the named parties in this case. In this case, an injunction limited to maximum defense and not extending to its customer and any intermediaries legally necessary to process sales would afford no relief at all. If the injunction excludes licensed dealers, retailers, wholesalers, and other third parties, there is no one who could legally accept or transfer such items free of the heightened NFA restrictions imposed by the final rule. An effective injunction pending appeal thus needs to cover all persons and businesses in the purchase chain from manufacturer to final purchaser, including all federal firearm licensees in between. And that is a very well articulated connecting of the dots there as to why a nationwide injunction would be the only remedy that could actually stop irreparable harm. The case, once again, is Mock v. Garland. We have already talked about it before. It's been ricocheting around, but now this petition sits before the Fifth Circuit Court of Appeals. The magical date to circle on your calendar is May 24th, and obviously we are going to very carefully watch this over the next week. If there is any other developments, we will be sure to let you know. In the meantime, if you guys get any other questions about the pistol-based rule or anything else related to what's left of our Second Amendment rights, you guys should know how to contact Washington Gun Law by now. If you don't, that's okay. That information is there in the description box. In the meantime, I do want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.